Hey, Angela. It's Jim O'Connell. Can you hear me?
I can. Good morning. How are you?
Good. How are you?
Good. Thanks for
Beautiful.
joining us.
Sure.
We haven't
Morning,
quite
Jim.
started yet.
There's Thaddeus. How you
Yep,
doing?
Good.
I like the flag in the backdrop. That looks cool.
Yeah, I was gonna get the Maine for this week. That'll be my goal this week.
It's good to shoot high with your goals.
Roger that.
The
good morning.
alternative is the bookshelf of power.
There you go. I got to work on that too. Bookshelf of power. I've seen a few people have a backdrop like that. Good morning, everyone. This is Bar Talk, May 18. It is Monday morning, and we've got just a few updates to share with you, and then we've got a great group of stakeholders that are going to give us an update on what happened Thursday and what we expect to happen this week. We all know now that or at least it was announced that Maine lodging providers can start accepting reservations for June 1st. For those that have clients that are in that industry, of course, that's good news, and you're going to also have to filter through all the things you can't do or that you're going to have to do. And so good luck there. If you do have questions or concerns that we can forward on, please let us know. On top of that, I just wanted to share May 18th, I believe, is the first day that restaurants can open in Aroostook, Piscataquis, Washington, Hancock, Somerset, Franklin, Oxford, Kennebec, Waldo, Knox, Lincoln, and Saginaw counties. Those are all lucky counties. And of course, comply with what requirements are necessary on the industry checklist. And courthouse hours were reposted for the next 2 weeks if you go to the Judicial Branch website. That being said, we now have MSBA representatives from the stakeholders group with us. John Gause from the Employment and Labor Relations section. Are you with us?
Yeah, just unmuted. I am. Yes. Hi, Thad. Hi, everybody.
Hi, John. Thanks for being with us. And if you could, we're just curious on you sharing your perspective of what happened last Thursday, what you consider the main concerns of your section, and where we're going forward.
Sure. I thought it was a productive meeting. There were a lot of participants, 33 altogether, and everybody stuck to the protocol of 2.5 minutes of comments each. And Chief Justice Meade invited any of us and any of the public who's interested in commenting on the court's plan going forward in light of COVID-19 to submit written comments as well. From the labor and employment section, as is shared by others who were involved in litigation matters in the court, the most important issue for us is getting back to jury trials. That's where all of the discrimination cases that are in court, or nearly all of them, are ultimately heading, is having a jury trial. So we need to get to the point where we can conduct a jury trial. Without it, the cases are just going to get stalled out. Laura White, one of our members, pointed out, how do you conduct a jury trial with a mask on? If the jury has to have a mask or witnesses have a mask, these cases are turning on, bias, prejudice. Jury's going to be making credibility determinations, and if the witness has a mask, you really can't do that. So some way of spacing out jurors, and Laura actually said that from her perspective, it may be better to wait and not have any jury trials until we can do it in that fashion, more traditional fashion without a mask. Brett Baber in our group suggested convening 2 advisory groups to assist the court in how to get back to jury trials without masks. And that may be more intense written questionnaires so that not as many jurors are coming in for jury selection. And a smaller pool of jurors for selection will make it more manageable. Other concerns of ours are the short statute of limitations, making sure that we can still file these cases in court and serve them. Maybe we could step up some of the early resolution efforts, including judicial settlement conferences. Overall, I felt like the meeting, again, was very productive. The court, Justice Mead was visibly appreciative of the feedback he got. He made the comment that a lot of the suggestions were ones that he had not thought of and the court had not thought of. And so I think that to the extent that we all can take advantage of the court's opening the doors to us to come up with creative solutions and providing those to the court, I think that the court is going to be very receptive, and we all have to live with the consequences of what the plan is going forward. So the more of us that can contribute to that process, the better. There is a written comment opportunity through May 21st that the court has posted on its website. And then we also have another stakeholders meeting this Thursday.
Great. John, thank you very much. And we may have time to circle back. We may not. But anyone that has any concerns, questions, you can chat them up in this chat here, or you can email them to either your section chair, John, or to us. Next on the list, we have Jim O'Connell, who is the section chair for our litigation section. And Jim, I know some of this info is overlapped. I'm particularly interested in hearing a little bit about what you had said about discovery too. But Jim?
Thanks, Thaddeus, and thanks for inviting me to speak on behalf of the litigation section members. I think it was a good opportunity for us to talk with Chief Justice Mead and be heard by the court system. My overall takeaway from it was that it was both encouraging and very discouraging. Obviously, Justice Mead and the rest of the court recognizes that we have an unprecedented, very challenging situation, and that there is not going to be a return to normal anytime soon, and that the court system needs to work to design a system that will work for the new reality, and with an acknowledgement that this virus and the challenges that it presents are going to be with us for quite a long time, and we're probably going to be faced with sort of opening and closing processes. What was encouraging is that the court is clearly actively working hard to try to figure out how to make the court system more functional for lawyers and litigants. Noticeably, they had a new pandemic management order come out, I think the day before the stakeholders meeting, which was very encouraging in that it said that the court is now open to a much wider variety of cases than had been. And by open, I don't mean that the courthouse is open. I mean that the court will be scheduling hearings and conferences for a much wider variety of cases, including civil matters, which the court had been closed to. So it was very encouraging in that regard. Secondly, they ended the automatic extension of scheduling orders. So as you all probably know, a previous order had issued or had extended all deadlines by 7 weeks. Under the new order, as of June 1st, that will no longer take place. So any deadlines starting June 1st going forward that hadn't been extended will not be extended. And new matters, I believe, will not have extended scheduling orders. So we were very encouraged by that because we need these cases to get going. the point I made on discovery was that in my observation, in every case, one side or the other seeks, well, I've already gone over my time here. We need discovery conferences because parties are seeking delays, and the courts are now giving that. My main point was that for all litigators, we need the scheduling and conducting of trials to resolve matters, and that's what lawyers want, and that's what litigants want. And it's nearly impossible to envision scheduling of jury selections anytime until there's a vaccine, and there's going to be a massive backlog. So I was very encouraging of the court to design some systems so that we can start working together transparently to envision and create a new way of working towards trials and working through the massive backlogs that are going to inevitably develop.
Thank you, Jim. I appreciate it. Next on our list is Amy Robidas from the Family Law section. Is she on with us?
Yes, I am.
There she is. Hi, Amy.
Hi, can you hear me, Ted? Okay.
I can.
So there are two concerns that I raised on behalf of the family law section specifically was a request that we get more information and guidance from the courts on the case. The regular questions that keep coming up from our clients are about, does contact continue to happen? How do I have this, does my custody schedule still take place? And my hope is that if we get more information from the courts, that will reduce the need of litigation, since the courts are just, getting back up, and we're not going to necessarily be able to get into court for quite some time on any of the contested cases. They do have some frequently asked questions. They do have a frequently asked questions section on the court's website, but it is just not as robust as I think would be helpful for the attorneys who practice family law, and then also just for the individuals who have to go through these family law cases without attorneys. The other concern that I voiced was about the lack of ability to mediate. Almost all of our cases require mediation prior to having any sort of hearing or trial. And as of this point, mediations through the court are just not happening. You can still retain private mediators who are using Zoom, but a lot of our clients or pro se litigants don't have the means to hire private mediators. I agree. It sounded like the Chief Justice really he listened to all these concerns, although it seemed like he might have been hoping to hear more suggestions. It sounded like he did have was aware of a lot of these concerns, and it was clear that the powers that be are working really hard to see how they can, to come up with ways to safely reopen the courts, which was, just positive to, it was encouraging to hear that. And also, sorry, he did say to expect to see a revised or a new PMO before June 1st. So we'll just be on the lookout, I guess, for new rules by the end of the month.
Thank you, Amy. And next we had David Austin. David, you represent the business law section. If there is something you'd like to share with us too about the concerns and what you see going forward for at least the business law concerns.
Sure, Thad. Thank you. Thank you for including me in the group. And I want to echo how much I appreciate the Chief's discussion. It was not only the discussion, but the thoughtful way in which he sort of managed 30 or 33 different interests on the phone. I think from the business community, it's really just being ready, because there's just going to be an onflow of need for access to the courts. I raised a question about whether the business courts would be expanding in terms of their scope of what they'd be looking at. I think the chief kind of acknowledged that everything's on the table right now in terms of access to the court systems. And I don't know that there was a clear answer to whether the business courts would take on an expanded role, the types of cases that they would be hearing. I appreciated some of the discussion around FEDs and a lot of our clients that are commercial landlords and those types of things. And also on behalf of I think Amy may have mentioned on the family law section, I think there's a real issue, and it was identified by the court that as we move into this new reality, are there going to be certain segments of the population that are disadvantaged in terms of access to technology? What does that mean coming into the court system? So I thought that was a very thoughtful conversation, but issues that need to be addressed. And as Jim and John said, and I think others who were on the call, the chief included, maybe these conversations should have occurred as an ongoing matter. There are lots of things that are going to be here, I think, permanently as a part of a new system. But it was a very positive conversation, and I appreciate being involved in it.
And David, thank you very much for sharing with us. Is Allison King on the line? She might not have been able to make it, she represents the real estate section. She was there also, but she did tell me that she may not be able to make it. Jonathan, I'm not leaving you much time. As a matter of fact, less than 60 seconds to kind of wrap everything up here that we've all heard. And Jonathan represented the Board of Governors of the MSBA and our general concerns as a bar in whole. And I'm kind of interested, I haven't necessarily heard yet on what the plan is next, if they revealed it even.
Thad, they did not reveal what the plan is next. They were going to take all of the suggestions that were made and try to go through them and find answers to the extent that they can. Pretty much everything was covered. There are a couple things that weren't. One is that the new order that ended the 49-day extension created some questions and some issues because if you have a deadline after June 1st, that stays in place. So there could create situations where things are now out of order. So for example, if the plaintiff's expert deadline is extended 49 days, but the defendant's expert deadline is June 1st, the defendant might have to reveal or designate their experts first. In addition, since the meeting, I've spoken with a number of attorneys, and I think I've gotten at least 2 or 3 different interpretations of how all that timing is going to work. So I did actually take advantage of the court's request for emails and did send in that there's some confusion and suggested that perhaps what they do is either extend all the deadlines so everybody has an equal amount of time, or probably more preferably that they have counsel confer with each other and set new dates so that things are put back on track. I think if counsel sets new dates, that way you're not going to, if I have a case right now, I need 49 more days. We got 1 deposition left. And so, if counsel could confer on new schedules, that would probably move those cases along. They definitely want to get back to jury trials. Part of the problem there is that the counties themselves are in charge of the courthouses, and they're concerned with what to do if you have to get, a few hundred people, 100 people, 200 people in the courthouse. So they're going to look at ways, I think they're going to look at ways anyway to perhaps narrow that down. Someone I think suggested that we have more robust jury questionnaires up front so that perhaps we can narrow down who's called in. And another thing that came up a number of times was to encourage judicial settlement conferences or mediation with the hope of maybe getting the dockets cleared up through resolution so that the cases that actually are going to need to be tried can be set on a schedule.
Thank you, Jonathan. I appreciate it. We are a little over. I would appreciate any questions that you have for our speakers today be pushed upward so that we can address those. I do see that there were a couple questions that were shared.
I think just one question about protection from harassment hearings, which from Fred, and then Nicole, I believe, answered that.
So my understanding related to protection from harassment hearings is that that they are being held. if you have someone that gets a temporary order for protection from harassment, my understanding is in Portland District Court, they are holding those hearings. That's my understanding. But I think that you'll get a notice from the court too, if for some reason that changes, which has happened in a case of mine. That being said, a real quick, any quick business updates, Angela, before we sign off?
Nothing that
Okay.
they can't read.
Yeah, the slide is there. We do have Bill Nugent coming tomorrow. All right. Thank you, everyone. I appreciate it. And thank you to the chairs. I look forward to something great coming out of the Thursday meeting.
Thank you all for joining us today. We appreciate it.